All right, Pryce, here. We've never done this before. This is sort of like an emergency. I won't call it a podcast. We don't have a podcast, but at least not yet. But we've had to with the stunning news that's come out today or yesterday about the lawsuit against Epic in Texas by the state of Texas,
My
led
home
by
state.
your home state. In the back of my head, I'm like, maybe we have an emergency, podcast or like something visual for regulatory reasons for HTI-5 dropping, as has been alluded to, but
I've been
which
I've been
still,
Googling the ASTP like every 10 minutes hoping that there will be something new, but it's just articles written by you about HTI.
I just keep, it's like that meme where the guy's poking with a stick. He's like, come
Yeah,
on,
yeah.
do something. You promised it. You promised it. Dr. King promised it this week. But instead, we get this lawsuit, and you're from Texas, boots on the ground. What do we got? What's the take?
Well, I can confidently tell you that nobody in Texas knows. Nobody cares. It's just the health tech nerds and you and I that are thinking about it. I feel particularly, I guess, divided between my former employer and my current home state, though I think it's pretty easy to say that living in a state doesn't mean you have to agree with everything that your state government does or your attorney general. So I'm excited to dive in to think about it through the lens of politics, through the lens of litigation, through the lens of technology. I think each one of them sort of provide a different answer to me of like why this is happening and what it will affect. But overall, you know, it's just regular Christmas time here in San Antonio.
What jumped out at you? What was the first thing you're like, I have many takes, but I'm curious from your perspective and your educated perspective of what was most exciting or were you most curious about. I don't know if
Yeah,
you've read the whole thing, the back, front to back, like I have to my daughter last night, but
yeah. Yeah, I thought about it. I thought my 1-year-old might enjoy it, but we stuck to the Christmas books instead. I think for me, anytime Epic is blamed in, some sort of big antitrust or monopoly manner, I'm always feeling like, yeah, they are the biggest electronic health record and they're super easy to gang up on because, just like when the Patriots or the Chiefs are winning everything, it's easy for the whole NFL to hate them, regardless of whether or not they're cheating. But at the end of the day, for me, it's always like Epic is a software system. If their revenue is $6 billion a year, they're like in the Fortune 500, right? Like not even in the Fortune 100. Um, it doesn't feel like the right place to attack if you're trying to solve the problem of healthcare and healthcare cost. It is probably the right place to attack if you're trying to set precedents in, the area of healthcare information and exchange like that. But as I'm sure we'll talk about a little bit more, I think this has a more pointed, plan than just information blocking or monopolies or anything like that. I think it's a little bit more about specific topics and political movements. And so that always gets me angry. I'm like, don't pick on, the nerds in Wisconsin. Hey, honest to God, you know, 9,990 of the 10,000 are just like trying to do their best and they're good people. Some of them might
yeah,
be more cunning or malicious.
it's interesting because you're gravitating towards these emotional topics, right?
Yeah.
And the things we intuit as we think about antitrust and monopoly so often are, does it feel a certain way? How does it feel as a person interacting with that company? But
Hmm.
the reality is market dominance isn't about that. Market distortion is about that. And antitrust, very particularly as a tool, is meant to stop market distortions in the face of market dominance. And so it's critical, taking a step back, let's not even go any deeper, just for those who
Hmm.
haven't seen the news, haven't read it, um, Ken Paxton and the state of Texas have accused Epic of antitrust. This is a more direct form of antitrust in terms of the markets and the markets they define than the two private antitrust cases we've seen. So we have Particle v. Epic, we have QRIS v. Epic, both with antitrust claims. Those were kind of interesting because the things they claimed, the markets they claimed, were payer platforms and managed care software, the kind of adjacencies that use what's called leveraging, market dominance in one area, particularly EHRs to leverage into a new market.
Mm.
Stickier ground. They're still leveraging and sort of tying in this case, but cleaner market definitions in the sense that they define EHR database software for acute health systems, EHR database software for academic medical systems, and EHR applications as three distinct markets, two of which they claim Epic has a monopoly, and a third which they claim it sort of through tying and bundling and leveraging that they've monopolized or start to monopolize.
Mm.
And so just at face value, that is a stronger, more straightforward path than the other ones we've seen in terms of, is it a reach from market definition? And
Right.
market definition is most critical first thing for every antitrust case,
Mm.
because it is the barrier that each case faces in the motion to dismiss, where if you want you can have a monopoly in a market. You can be 80%, 90% dominant. A natural monopoly is what that's called. And that's okay, so long as you're not acting anti-competitively. Likewise, you can act anti-competitively, but if you don't have market dominance, it's not antitrust. If you have 10% market share, you can and so often do actually all the things that are alleged in this complaint, right? Like many small startups will do and preclude access to APIs or charge exorbitant things or behaviors that are anti-competitive, but they do not have market dominance and thus cannot distort the market by those behaviors necessarily.
And they're not breaking other laws, like if they're not certified health IT, they're not info blocking, or they're not actors, I should say, in info blocking. So let me ask you this: like, given the sort of laid out markets, like what's your take? Do you feel like those three markets are three distinct markets? Because you've mentioned that in your article, and I feel like it's hard to. I mean, unless you're talking about a headless EHR, which is still a tiny fraction of healthcare software, there's not. I don't really understand the whole take on this is a database system versus an application suite.
Totally, and you're right to hone in on that one. There's a number of challenges that will be faced, and we can expect Epic to rebut this with initially. I don't know which angles they'll take, but there's a couple kind of glaring ones. And the first is, as you define these markets, they need to be, tied to commercial realities. And so the first thing that's pretty glaring to people that have worked at Epic, worked at other EHRs, worked in the industry, is the buyer, health systems, typically isn't buying an EHR database, right? And very rarely do you see any EHR where it's like, let me swap in PostgreSQL versus the next thing. As we shift increasingly towards the cloud, towards SaaS platforms that they're hosted somewhere, it's just yoked to the Athena is up in the cloud and the Athena world, and you don't choose which database is under the hood.
Yeah.
So like that nomenclature at least is off-putting to people and could affect the case in a way that maybe it's fatal, maybe it's just precludes them from or forces them to amend their complaint, would be what I imagine might happen, that they get dismissed without the ability to refile and amend. And that's one possibility. The second thing that just sort of jumps out from market definition is they do this odd thing where they have the three categories, right? They have EHR databases for academics, EHR databases for acute, and the apps. And you'd kind of be like, all right, there should just be one core monopolized market, and then the tied market, right, is what you traditionally would expect. So you start to say, like, okay, why did they do this? And reading the tea leaves a bit, you sort of sense weaknesses in both of the two core markets, right? The acute market, do they have market dominant market share? Are they destroying the market? Do they have enough market weight? Because if they don't, which is typically like 60, 70, 80%, but usually like 70 or 80%, then you're going to have challenges, or at least in the last 40 years since the Chicago school train of thought in antitrust took hold. You really need to have this strong market share, ties to consumer welfare standard. Looking at that first one, the acute topic, does not have, maybe they have 50, maybe 55.
Yeah, not even.
Yeah.
Yeah. Yeah.
On the academic side, it's sort of, you start to look at that and you say, well, is that a distinct market? Are academic medical centers, did they purchase a different set of software that's not interchangeable with what is more broadly bought in the acute market?
Hmm.
All this sort of definition of the market winnowing down, often referred to as gerrymandering, which is kind of funny
Yeah.
in the context of Texas,
Apropos right now, yeah.
is ties back to the actually this Oracle case, 2000s, where Oracle was sued by the DOJ. DOJ said, "Hey, high functioning enterprise HR software is monopolized by Oracle. They're purchasing PeopleSoft. This is antitrust worthy," and they lost because the judge said, "Actually, you've gerrymandered the market." Things have changed a lot in the 25 years since then, but precedents are there for systems of record.
So for me, it's funny, earlier you mentioned sort of my emotional reaction, which is may have, it has no legal bearing, right? I'm not a lawyer and my emotions are not like legal artifacts, right? But from this market definition perspective, I am thinking like, okay, there's a legal tactic of if we gerrymander the markets appropriately, then maybe we can show that there's additional dominance, like let's exclude all of the, mom and pop clinics and let's just talk about Epic dominating the whales and separately the academics, which they talk about as well, right? Like they internally talk about, we go after the whale systems, we go after the Mayo clinics and the Cleveland clinics, we go after the Kaiser Permanentes, then we go after academics and then pediatric hospitals, right? So gerrymandering those, if you will, is an interesting legal tactic. From an emotional perspective, the way that they talk about the EHR database, it's probably going to resonate more with the public that Epic manages and holds and keeps and hoards your medical records like Smaug sits on, gold and the Lonely Mountain, right? And that's always ironic to me because, Epic doesn't own any of this data. It's most of most of their customers aren't even hosted in Verona, right? Like they're self-hosted. It's on Epic software, yes. Who configures it? Who manages the database? The hospitals. And so it's even, if I don't think that definition of saying, oh, Epic is the one who hoards all of these charts and they hold your charts and therefore they hold so much power. Even if I don't think that's true, the emotional implication and the political implication is certainly impactful because people are thinking, yeah, what is this little company in Wisconsin? Why did my nephew have to move to Verona right out of college instead of staying in Texas or whatever? And yeah, so it's just like that's what I keep seeing is what's going to hold up in court, but what's also sort of maybe advantageous to the public, to any party based on
Court
how
of
it's
public
perceived.
the court of public opinion matters, right? I mean,
Yeah,
it could be a jury trial, right? Like you get all the way down to it. It could be a jury trial where you certainly want to have the court of public opinion on your side. It could go bench, and often antitrust does because of some of the complexities. But by and large, it also could be emboldening for others to do private cases or other states to push on Epic. It certainly gives leverage to people negotiating with Epic in different capacities. And so certainly the optics play into it. And then, you know, there's still some other topics on market definition we could go into, but like, let's just go straight into optics. Ken Paxton is a very optically forward figure,
yeah.
a contentious figure, in everything he's done in being a staunch conservative, um, supporter of Trump during some of the more contentious topics like the 2020 election, certainly abortion, certainly trans rights and things like that. Like he has been a conservative.
We're seeing a clear line from this case to trans rights and you know, minors having access to their data and parents having agency over everything that their kid does. I mean, heck, I started sending my kids to school this year thinking that they were going to have the 10 commandments hanging in every classroom because that was happening in Texas. And so, yeah, there's a clear, you know, line being drawn here from sort of some of the points made in this case and the political atmosphere writ large,
Yeah,
you know.
I mean, they lumped in here. It's like a pretty good antitrust case that would be like fascinating to follow along with. And then they're like, well, what if we throw in parental rights? What if we take this thing that the do no harm sort of lobbyist group has been pushing of Epic and Oracle and these EHRs, they promulgate the settings to their hospital customers so that parents can't access their kids' data, at
Mhm.
13 or 16 or whatever. Like the thing about it is maybe they're right or wrong, and so maybe certain hospitals don't flip the switch. I don't know, but like in my experience, these hospitals, they have a lot of lawyers, they have a lot of implementation staff, and they are certainly not going to go violate state law. And so setting those things up correctly is of paramount importance, and they certainly have resources to do so. The failure or error to do so kind of is on the hospital in my mind. This is a hot topic, trans rights, and sort of the HIPAA intersection of that has been in the news recently, and Ken Paxton is taking advantage of that in many ways to lump this in here, give it the glow of antitrust to make it not just sort of left versus right culture wars type of thing, advance the agenda of President Trump, advance the agenda of the Conservative Party. And that cannot be seen without the backdrop of him running for Congress as well.
Yeah.
I've gone and crusaded against Epic and these other tech giants that are pushing down liberal values. I wouldn't be surprised to see that dialogue pop up as he starts to really move forward with this congressional run.
It's funny, you always talk about software bundling, and now we see like argument bundling here, right? Like just sneaking certain thoughts in with other thoughts that more people will get on board with, and obviously that's just politics.
That's part of it. I mean, it's politics. It's court cases. Like you need to be strategic about these things. Personally, I'm like, keep my antitrust away from my culture wars stuff. I don't think it does, like it really has that much synergy. I don't think there aren't that many strategic angles except for the optics and sort of getting everyone on board while advancing the agenda. So it's sort of just like, I want to analyze this and not have to deal with or separately, partition the social and cultural aspects.
Well,
the other interesting angle, I don't know if you're going to maybe go this direction, but is the choice of venue, right? Is the strategic part that I think is super interesting. I don't know if did you notice that it's in Texas court and not federal court?
Yeah. I mean, I don't know anything about how advantageous or disadvantageous that could be. Obviously, home field advantage is a serious thing, right? But when I think about Epic's lawyers, I think about people who know everything about healthcare policy, regulation. And then when you think about, Texas state law, it's an abstraction away from just hometown. What is Verona or Madison, Wisconsin excited about, upset about, or, the federal government when it comes to the HHS and info blocking and certification. Having it in Texas is definitely like, okay, well, I know for a fact that you can't work for Epic and live in Texas unless you've got some special position. So yeah, tell me more about like, why do you think that's going to become important if this case proceeds? And maybe a little bit on like, I'm always curious. Okay, so judges are meant to be impartial, but they're all human and they come with their own opinions and sort of default settings. And so I'm curious, like, do you think that plays into any of this in and of itself outside of state law? Is it like interpretation of law that will also become a thing?
Totally. Federal judges appointed, right? And that, as there's partisan swings, you see Obama put his in place, Trump put his in place, Biden put his in place. And so you see, and they try and stack the courts and stuff like that. But like by and large, you get bipartisanship at the federal level, or at least multiple viewpoints in states, and they're elected. And so just think about the implications of elected, officials, even if they're still supposed to be the law and impartial, they're still just like who they are and who they're elected by. That plays into things. Yeah. The jury pool is another aspect of, okay, a bunch of people from Texas in particular area could have an effect there. But the bigger pieces to me are they chose to stay out of federal court. They could have easily said, I'm going to go put a Sherman Act claim, the federal antitrust law that's applicable here. Instead, they said we're going to use I almost said TEFCA because it's very close. The TFEAA, the antitrust law of Texas, which I'm not a lawyer either, but I know a little bit about the Sherman Act. I know very little about the Texas Antitrust Act, but my understanding is that there's supposed to be harmonization. They're supposed to flow down and harmonize with federal law, but there's more discretion at the state level. Yeah. And so I think they can get through some of the minor flaws in or weaknesses in the market definition via state court. I think that's a very strategic choice by them because they just say, okay, maybe I get a little bit more flexibility. Once I get in the door, and we get to discovery, they actually in there, they're like, this is what we're claiming, but we leave room to maybe add things in as we go through discovery. And like, they're leaving the door open to find things out, maybe amend the complaint or whatever, and then, rip on what they see as actual anti-competitive behavior or revised market definition, things like that.
Okay. So market definition is one of the few things that needs to survive, a counter argument to move forward into discovery. So let me ask you this, like my first perspective on the proxy access, to healthcare charts and things like that. I was kind of feeling like, okay, well, Houston Methodist and Texas Health Resources, like those folks have agency to change nearly every setting in their Epic instance, one of which could probably be, you know, who has access to which charts, how do you set proxies. Patients and parents and caregivers always have access to, it's very common for them to have access to, the my chart for someone else. And I was feeling like, geez, this would be like suing Toyota for me driving 90 miles an hour on a road. It feels like Toyota made the car, but I'm the one using it, configuring it, right, to my interpretation of law or lack thereof. And so is that something like that the initial argument can say like, oh, this has no merit because we don't even play a part in making that decision? Or would that be something that happens during discovery because it's like a technical question and things like that?
No, that's a good question. And like, so the order of operations here is that there can be some pretrial motions. There's going to be a motion to dismiss, and then we move forward with a formal answer to the complaint, and then we go into discovery. Typically, you'll see for antitrust like market definition and those things as the angle of attack to push back because it just works, it's effective, and the bar for antitrust should be high because it is quite disruptive to businesses. On this other claim, which is not antitrust, any claim has to be plausible. So that the judge, in the pursuit of judicial efficiency, not trials are expensive and messy and time consuming, and we should be spending the judge's time on the ones that are important. They have the right to dismiss, right, with these motions to dismiss. They say, okay, yeah, like let's move on. This is not plausible. So yeah, based on something like at a high level for these claims, expect Epic to push back. Like this is not plausible. This doesn't make any sense because it's not even. We shouldn't even consider it. We shouldn't waste your time, judge, because and we'll see how they approach that. I think some of the things you list seem reasonable, but again, vibes and intuition don't always match the law, and that's what needs to be applied for any of these. Is that what we feel is right or wrong? Often, many people say, well, Epic is the clearest monopoly. I saw this on LinkedIn today. Some guy's like, Epic is the clearest monopoly I've ever in since Standard Oil. It's like, where are your measures here, bud? Like, you can feel it, and certainly do. Like, actually getting to the claims, which I know there's a ton of it's obscure, obfuscated, it's redacted, so we don't really see a ton except some of the vibes, some of the intent.
Yeah.
But like anyone who's developed in healthcare has felt from EHRs that they are blocked from competing fairly. Anyone who's developed with a system of record has felt that the system of record has in property management, in banking, just this incredible superpowers compared to them to cross-sell and upsell in a way that is unfair. And so that is underpinning everything here. So you're going to see a lot of empathy on those counts from people.
Yeah. I mean, that amazing Acquired episode, the podcast by those fellows who talked about Epic for 4 hours, they were incredibly smart. Their research in the space I thought was really well done. And it was fascinating to hear from someone who's not specifically devoted to healthcare that their opinion is like, of all the systems of record, of all the enterprise systems to exist in the business space, the electronic health record must be one of the hardest to displace, one of the most ingrained in, the lifeblood of every organization that it's, taking part in, because it's the billing system, it's the clinical system, it's constantly regulated, it's private information, it's people's livelihoods. People spend money on healthcare because they have to. At that point, it's like, am I, survival mode. So it's just such an interesting industry in particular to have a system of record and then, have complaints, from Ken Paxton saying it would take billions, it would take decades to switch off the system of record. I don't think that's hard to dispute. Maybe how you go about arguing that particular point and how you say like where are those billions spent? Is it spent at Epic? No, it's spent on, project management and all sorts of costs. But for sure, it's one of the hardest software systems to actually displace from a competition perspective. And that's why we see the federal government sort of pushing the limits on info blocking is not allowed. And your software, if it's going to be compliant, it will have to allow for the exchange of data. And in a way, it will have to allow organic competition and startups and, across enterprise systems, it will have to allow for friendly exchange of data in some sense. So one of my follow-up questions for you, I want to hear what you think from a market definition perspective is like advantageous to Epic versus the state of Texas. Like, how are you thinking each of them could get a foothold and why? I don't want to make you take a side, but I'm really curious, like where you saw pros and cons.
Yeah, I mean, just we highlight some of the market definition stuff in terms of acute versus academic versus the database. I think with a little cleanup, maybe they get to something plausible there. They get to discovery. Um, that they need to get to for those two because the leveraged market, the app market, is is downstream of it. So like it falls apart if the core market isn't solid, isn't monopolized. So I think that is critical. And some of the stats they list kind of weak, right? Like 90% of patients have an Epic record. Well, probably like 70% of patients have a Cerner record. Like it doesn't add to 100, it adds to like 500 or 600
Mhm.
because my record is splintered across the ClinicalWorks, Athena, Epic. And so that's not a traditional market metric or measure that we'd use here. And I think it's stressed it may not be sufficient to show market dominance. It's sort of a vibes-based one because 90% is like, whoa, wow, that's close to 100.
Mhm.
One thing I'll note is that like you said something that was triggering, I guess, for me, which is like, oh, like we're unique in healthcare. Our systems of record are the hardest to displace. I think this is true in every industry. Like maybe because we have the most data and we're the most advanced in terms of like all these subsystems and like all the money we spend here, but core banking systems have been around since like 1950. You cannot rip one out. It's just impossible.
Yeah.
Enterprises at every level go through this. Government systems like Tyler Technologies dominates government systems. You can't remove these ancient things. So I think systems of record everywhere have this exponential competitive moat of switching costs that goes up exponentially with data density and size of organization. And so it's not linear in sense of, okay, every incremental user or consumer that interacts with it just goes up a little bit. It's like, no, it actually goes up exponentially in terms of the data you produce, the switching cost. And that leads to the paradox of antitrust for systems of record is that they almost always fail what's called the SNP test, which is this test in antitrust to say, with a small but significant increase in price, would someone switch to
Mm.
another competitor? And if you measure Epic, the answer is no. Like they raise prices, no one's going to switch. But you did for Oracle, the answer is probably no. If you did for Athena, the answer is probably no. Like it takes not a small but significant, but a large but significant price for them to go, well, that is higher than the cost of migration. The cost of migration in terms of data transfer, in terms of retraining, in terms of reintegrating systems is huge. So it is a large but significant price for somebody to go, I got to change over. So by that test, everybody's a monopolist when they're a system of record, when they're an EHR. And
Yeah.
then you look at market share in both EHRs and system of records, and you say, wait a minute, all of them are like 30% market share, up to
Right.
50. Very few are 70 or 80. It's not like a network-based business where like you see networks converge to ubiquity to 90% because
Mhm.
railroads, telecom,
Mhm.
e-prescription, like network-based businesses, you need to get to ubiquity, and so they fight very hard to get there. Whereas
Mhm.
systems of record can be very, very dominant at a much lower. And so antitrust as a tool is ill-equipped. Our historic antitrust laws are ill-equipped to deal with systems of record, which is why they failed against Oracle, which is why they didn't really work against Microsoft. If you look back at that case, And like, yeah, they won and settled, but like, not really. Where's Netscape? And so systems of record, operating systems, those types of technologies, there's this, we need different tools.
Hmm.
Enter scene information blocking, right? Like
Mm-hmm.
information blocking as a pro-competitive law is
Mm-hmm.
really, really interesting because it allows for the outcomes that we're trying to achieve here, right? Like everything about here is like, hey, Epic should be interoperable with these applications. And so information blocking law, interoperability laws, like those are the logical remedies to any antitrust case against Epic or any system of record that you would
Mm-hmm.
say, hey, if you're doing it in your app, you need to make the same APIs available to the other apps. And
Mm-hmm.
that is sort of how information blocking is playing out. And sort of why I'm so bullish on that law and that rule compared
Mm-hmm.
to antitrust, because the bar is not as high in terms of antitrust is extremely high bar, and it achieves a similar policy goal, similar outcome in terms of the ecosystem, in terms of apps being able to compete, in terms of pro competition.
Mm-hmm.
But what it doesn't achieve is pushing Epic down a peg. So people looking for that outcome, antitrust is probably the right tool.
Interesting. Interesting. And who do you think is pushing for that outcome most, or who do you think has been hinting at pushing for that outcome?
Like the outcomes we want to achieve should be driven from thinking about what is pro competitive. How do we build a pro competitive marketplace where providers have choice? Because choice of applications, choice of tools, the thesis there is we give them that choice, healthcare will be better. Remains to be seen. Like we need to get there to see if that thesis plays out, but it's a noble one and it's a good one. And so in that, in that arc, information blocking as a pro-competitive law, like if you segment it out from like the consumer access, the data migration pieces, it's pro-competitive to allow competition on the marketplace that we see play out from real-time medical versus point-click care into scare versus RTZ. All these information blocking cases are cementing that angle of information that innovators, applications should have fair access. And so that's, if they're not aware of that, not using information blocking, then I imagine people that have felt blocked are rooting for this.
Yeah.
If you're looking for tinfoil, let's put the tinfoil hat. It's like people are like, well, this is in Austin, and Oracle's based out of Austin, and Larry Ellison is buying Paramount and doing all these things. Like, so if you have like a nefarious view of Oracle and Ellison, then there's plenty of narratives you can spin. I don't buy that. I buy more this case coming back to Paxton running for Senate than I do any of the who's banking this type of stuff.
I wonder how this ended up in his crosshairs. Like, obviously, we talked about a little bit of the potential political motivation. It's just so interesting to me, like how one thing can be plucked from the bunch and thought like, oh, that's what we're gonna do right now.
It's like people wonder a lot about like who seeded this, how did we get here, like, who's manipulating and pulling the strings. I don't know. There's investigative journalists that can go and try and figure that out. But like you end up wasting a lot of time because a lot of times it's arbitrary. It's not one thing. It's not the guy in Lord of the Rings whispering in the air.
I'm a worm tongue.
Worm tongue. Yeah, like it's the aggregate frustration of an industry that's not solving the problems, right?
Yeah.
Healthcare, the frustrations that are bubbling up, they are lumped at our insurers, they are lumped on the feet at the feet of our tech companies, just like in other industries we see it tech taking some of the heat for outcomes we have socially from
Yeah.
technology advancing and like
Yeah.
rightfully or wrongfully.
Yep.
And so I think it could be someone whispering, but by and large, you end up spending too many hours searching through the donations to
Yeah.
campaigns and things like that and finding nothing because it really is aggregate vibes and that are feeding into the discourse. And so we shall see.
Yeah. Well, and I also like if Ken Paxton doesn't like Epic, he's not unique for that. I'll say that. Like he's catching plenty of people's attention with that move for sure. So one more thing I was thinking about, I think you called this out in your article, is sort of if you think of Texas specifically, Texas and California are states that have strong political identity, if you will, and at least generically. And in the past, we've seen Texas sort of favor non-competes. And now they're invoking in this argument that Epic's non-competes are really detrimental to the industry. What are your thoughts on that? What are the details there? I didn't read into too much of it.
Yeah, I mean, it's interesting because, under Lena Khan, under Biden, FTC advanced this rule saying like, hey, non-competes are by and large not allowed.
Hmm.
And it was in Texas that was struck down where they challenged it and they said actually FTC doesn't have authority. And then we switched admins and the new FTC said, you know what, we're gonna let this one go
Yeah.
because, from a conservative standpoint, they're more pro-business and things like that. And so then you see this and you're like, wait a minute, one of the claims against Epic is about the non-competes and the use of non-competes and you're like, all right, Ken Paxton, like, thank you. Like,
Yeah.
you're on board with this now. But it's, you peel back and the motivations are different, right? Like, the Democrats are pro-labor historically. Maybe not now,
Hmm.
but like historically, that was their strength. And as part of that, it's like, okay, let's non-competes restrict labor's ability to move and get a better salary, to create new
Yeah.
businesses, whatever it might be. And so in a pro-labor scenario, you would get rid of non-competes to allow them to move to wherever is offering and have the companies compete for the best labor via benefits, via a satisfactory workplace. That underpins the Democrats' push for it. In my own personal views, I think that's great for capitalism, but not the case necessarily here where it's tied to monopoly, to antitrust. And in
Hmm.
this way, it's actually about the competition, organization, businesses, where Texas is saying, well, we're suffocating potential businesses because
Mm.
labor can't move. And so their motivations are much narrower in a way that it's not like, let's get rid of non-competes. Like, no, 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 non-competes can't be for the biggest ones because you're too big and thus
Hmm.
suffocating vibrant businesses. It's about businesses, not people. Is
Hmm.
kind of what underpins it. I just find that it's like if you're pro-capitalist, like you should be favoring dynamic, fluid innovation, and that will happen from liquidity of talent moving to the best businesses, creating the best businesses. And so I find it kind of like do it one way or the other, and then this
Hmm.
half-baked use it only when it selectively doesn't resonate with me, but certainly
Yeah.
overall, I think you can be like, okay, Epic's non-competes. No one's ever going to go and defend those. I don't know. You or I are not going to get up on this and stump for that.
So, so let me ask this question. You might not know the answer, but the initial case in Texas that you were saying was against non-competes and struck down. Was that a federal court? And now we're going to deal with state courts under this new argument from Ken Paxton, or are they the same sort of, you know?
Texas isn't just like all non-compete, no non-competes, anti-non-compete. That's like they've gone after like health system non-competes, like very targeted. Like this company is hurting competition. And
Hmm.
so in the case of the health systems, like they're distorting the local market when doctors can't jump over
Mm.
and like this other hospital is dying as a result. Like
Hmm.
that is when they care. And so it's in the case, it was, hey, by banning non-competes, you, FTC, the Federal Trade Commission can just, there's no congressional authority, I think
Hmm.
is underpinning that case. And, like that is a different like blanket, not, anti-non-compete that's not where Texas falls.
Yeah. Interesting. Man, there's a lot to digest here. I'm glad you got your new court case after getting a whiff that one of your other favorite court cases might be.
I'm so bummed. I'm so bummed. Yeah, like it looks like real-time medical systems and point-click care will settle, which is good. Like we both those companies need to go do good things. But from a setting perspective, it
Yeah.
would have been exciting and interesting to see courts decide more thoroughly some of the intricacies of information blocking.
Yeah, I was
But
gonna say,
luckily,
what does that rob you of exactly? Like, so I thought we already saw in that court case, we defined that the exchange of healthcare information, electronic health information, should even be allowed through something like robotic process automation, legally be discouraged. What else, I guess, would have shaken out during that court case that you would have felt like is, like I said, you were robbed of sort of seeing how it would pan out and precedent being set?
yeah, no, it's a good question. It goes into like sort of the steps of the case, right? Like a point click care, that case was in the stage of like they'd gone through a preliminary injunction hearing and decision where the district judge decided for real-time medical systems in a precedent-setting way in their interpretation of information blocking, in their interpretation of how federal statute could be used in combination with state tort law. That was challenged and appealed again, still like, was the preliminary injunction ruling correct? Was the appeal, and the appeals court agreed with it, again, solidifying some of that interpretation. But at the end of the day, you need to go through the next step of the trial, the actual discovery and trial itself, and get to like real decisions to set hard precedent, or to get to go through the facts intensive piece where they could go through the facts and then the judge could be like, from a bench trial, could be like, oh, actually, here's what we think, or here's another level of nuance, because that is tons more data, tons more information about actual security, actual performance, all this stuff. And so preliminary injunction is like sort of speed run of it and make kind of light decisions. And are things plausible or not? Is there real harm to the business in being prevented? In the case of the preliminary injunction, real-time medical systems, this app, when cut off, could have gone out of business. And so that underpins maybe the decision there of like, okay, it's plausible enough. The legal grounding is sound enough.
Yep.
Let's go to trial, but then maybe they decide for PCC. Who knows? I was generally thinking like 60-40 towards real-time medical, and just the way the things were breaking. If they settle, we'll never find out. We'll have to wait to, Intiscare versus RTZ.
Well, if what we're hearing from the HHS is true, we're not done thinking about info blocking and the intricacies of how it could be defined, et cetera.
If you know any good lawyers, OIG is hiring up to 5 lawyers for information blocking, so they are revving their engines. So, yeah, well, lots of fun, Pryce. I hope you had fun with this, and
Loved it.
Let's see if the internet loves it.
All right. Thanks for chatting.